afternoon and welcome to our webinar, our 6th webinar series. My name is Millicent Shitaha from the Nairobi Center of International Arbitration. Thank you for joining us. We'll be discussing on the subject matter for the next 1.5 hours. And at this point, I would like to welcome the moderator, Mr. Collins Namachanje. Collins.
Thank you, Millicent. I welcome us all to our webinar session for this afternoon or this morning, depending on which part of the world you're joining us. Welcome. My name is Collins Namachanja. I'm a director of the Nairobi Center for International Arbitration, and we'll be moderating the session for this particular time. Our theme is the art of award writing for arbitrators. That's our theme for discussion for today. And I have with me some very well qualified and eminent panelists whom I wish now to introduce. We have with us Professor Ike Ehiribe. He's a fellow of the Chartered Institute of Arbitrators, and he's also a chartered arbitrator, barrister, and he was called to the Nigerian bar in 1982 and to the Bar of England and Wales in 1996. I was chatting in my side and saying 1982, I was just finishing my primary school to get into high school. So in 1996, he was called to the Bar of England and Wales by the Honorable Society of Lincoln's Inn. He's a fellow, that's 1994, of the Chartered Institute of Arbitrators in London, and also a chartered arbitrator in 2007. He's a fellow of the Asian Institute of Alternative Dispute Resolution, based in Singapore, and accredited mediator of the Academy of Experts in Gray's Inn, as well as SEDA, mediator in investor state disputes. He's an international arbitrator and dispute resolver practicing out of Sevenstones Commercial and IP Chambers based in London. And he's also listed on the United Nations affiliated WIPO panel of neutrals based in Geneva. He was an officer of the African Council of the London Court of International Arbitration between 2013 and 2019. He's also a member of the Investment Treaty Forum of the British Institute of International and Comparative Law. He's a visiting professor and fellow at the Center for International Legal Studies in Salzburg, a part-time professor of law at the School of Law, Christchurch, Canterbury University, England. He's an approved tutor, trainer, and assessor on the arbitration, adjudication, and mediation training courses of the Chartered Institute of Arbitrators in London. He's one of the co-conveners of the nascent Mid-Atlantic Caribbean Institute of Alternative Dispute Resolution. Please join me in welcoming Professor Ike. And then we have with us Jerry Kariuki. Jerry is a chartered arbitrator and accredited mediator who practices from Nairobi, with her primary profession being grounded in the law and being an advocate of the High Court of Kenya. Jerry is a fellow of the Chartered Institute of Arbitrators, and she has been cited in Chambers Global since 2014 to date as a leading individual. Jerry is a Government of Kenya nominee to the panel of arbitrators at ICSID. In May 2019, she was appointed to the ICC International Court of Arbitration as a member representing Kenya. And she has, in the very recent past, been cited as one of the top 30 African arbitrators, and I may add Professor Ike was equally cited. Jerry's arbitration, litigation, certified secretary, conveyancing and mediation practice covers a range of domestic and international commercial matters, and on account of delving into the realm of adjudication, became a DRBF member and thoroughly enjoyed a 3-year stint as chair of a dispute adjudication board set up to midwife an international geothermal project to fruition. Jerry is also a tutor and trainer with the Chartered Institute of Arbitrators and conducts courses and assessments in Kenya and anywhere else her services may be required. Please ask again that you join me to welcome Jerry. And last but not least is Angeline Welch. Angeline is a barrister based in London, UK, and is a well-known and highly regarded arbitration expert, having specialized in this field for well over a decade. In 2020, she was recognized as a global leader for arbitration by Who's Who Legal, having been recommended for some time as both a thought leader and leading junior at the English bar for arbitration. She is described in Chambers 2020 UK and Global as having an impressive mastery of the details of a case and of technical legal arguments, as well as extremely hands-on, approachable, and a real team player. Angeline was named as a star at the bar by Legal Week in recognition of her excellent judgment and leadership qualities, and not being frightened to tackle novel and difficult areas of law, or to deal head-on with the more complicated aspects of a case. Angeline is currently co-chair of the IB Arbitration Committee's ESG subcommittee, which is currently focused on the use of arbitration to resolve business and human rights disputes. She also serves on the ICC UK Selection Subcommittee and on the Arbitration Committee of the Lagos Court of Arbitration. She regularly speaks and writes on the subject to arbitration law and procedure, and is currently editing the 25th edition of Russell on Arbitration, which is the leading textbook on English arbitration law. Angeline actively accepts arbitral appointments. Since 2016, she has been appointed in some 20 arbitrations as sole co-arbitrator or presiding arbitrator. That's our team this afternoon, ladies and gentlemen, and join me again in welcoming them. Our session is scheduled to run for about 1.5 hours. Each panelist will take about 10 to 15 minutes to make a presentation. And then at the end of the presentations, we will run to the questions and answer session that we'll be looking at any questions that the attendees may be having. That then invites me to say that if you have any question, please use the Q&A chat and write or post it there, we'll pick it up. The topic, as I said, is the art of award writing for arbitrators. I've always looked at writing an award, as it were, as if one is in the kitchen baking a cake. So you have the ingredients set aside, you have, I think these days people go for cake mix first. It's already pre-done for you, so you don't have to mix the flour. So you have the flour, you have the eggs, you have the butter, you have everything else. You have your cooker ready, and then you start the process. At the end of that process, some of us who have very sweet teeth will be waiting to sample and then accredit. Have you passed? Have you not? And at the end of an award session, we have people waiting. The parties themselves, there's the court waiting. There's even yourself to assess, have you justified why you are paid? So they will help us to see how we can mix those ingredients properly to come up with an award. That is what the two ladies and the gentlemen are going to help us run through. So the topics that they will look at is the key components are parts of an award, and then distinction between awards and procedural orders, and then tips and techniques of an award writing process, and then emerging issues will be the last aspect of the discussion. So please join me to welcome Angeline to take us through the first part of the presentation, touching on the key component parts of an award. Angeline.
Thank you very much. I'll just bring up my slides. So thank you very much to the Nairobi Centre of International Arbitration for asking me to speak today, and to Director Collins for such a wonderful introduction. Just continuing with the analogy of drafting an award and whether we are making some tea. What my session is really looking at is what is the recipe for drafting an award, if you like. And one of the things I was thinking about before speaking today was thinking about fundamental techniques. And because the title of our session is The Art of Award Writing, I wondered to myself whether artists regard fundamental techniques as particularly important to their work. My quick research on this reveals that in fact they don't think that technique should override the art that in which they're engaged. I've put one quote on the slide, which you can see here. All the technique in the business won't guarantee you success as an artist any more than painstakingly learning every tennis stroke will get you to Wimbledon. You can only be sure that you won't get there without them. So my session is looking at what is the fundamental techniques which you need, or the contents of an award, which will allow you to deliver an award which is enforceable and also meets many of the key requirements of arbitral institutions and expectations of the parties. But what it won't do is tell you how to become a good arbitrator, and I think what you will see from my fellow panelists when they speak, that they will be able to share lots of tips and techniques as to what turns an award from being the setting out of the recipe to something which is a work of art. So let me get back to my ingredients list. The first section of my presentation deals with what are the mandatory requirements for an award. It may be surprising to some of you, or at least it was to me, and I'll come back to that why. And so when I first started writing awards, how little is actually mandatory. The list is really short. The starting point to ask yourself that question is, what are the potential sources of law which govern what needs to go into the award? There are three sources. The two which I've set out in the slide, the first two are probably the most important. One is, what is the law applicable to the procedure of the arbitration, the lex arbitrae, which is normally dictated by the seat of the arbitration. And that will set out what are the legal requirements there which you must meet in order for your award to be legitimate. And frequently it's the case that all the law will cite, the law applicable is that there should be reasons given by the arbitrators. The second most important source of the rules which govern what is mandatory for your award is the rules of the procedure. And quite often those will be institutional rules. It's very typical for arbitration agreements these days to stipulate what institutional rules are incorporated. And last is party agreement. This, in my experience, is quite rare, the extent to which parties would actually set out what an arbitrator must state in their award, but it's not beyond the realms of possibility. So, as I said, the mandatory requirements of what actually must go in your award are very minimal. It's often that the award must state the reasons given by the tribunal. And of course, that's really important, because when it comes to whether or not an award is challenged, one of the reasons upon which an award can be challenged is if they haven't given reasons, and also the reasons will allow a court to consider whether or not the arbitrators have taken into account the key arguments which have been made by both parties and considered them. So the reasons is the most critical thing, but often institutional rules will also require that the arbitrators sign, date and place, state the place of the award which is made, or sometimes place is referred to as seat. And I've set out some of the institutional rules references and model law references where those requirements are set out. So if one steps back, actually, in terms of what you must put in an award, is fairly limited. So to have a workable award, you wouldn't really need to cover a whole amount. But of course, that's not the way in which awards are drafted. And so what I'm going to now talk about is what is the recommended content of the award. There is, I think, an increasing international consensus as to what the expectations of what should be covered in an award. And this is recommended content because obviously what you set out in your award and the way in which it is structured will very much depend on the circumstances of the dispute. So if it's a very factually heavy disputed arbitration, then the way in which you tackle the facts may be very different to an arbitration where the key issues in dispute are legal ones. But just setting out what is the recommended content. So it is, I think, always appropriate to start your award with a short introduction. And in that introduction, the purpose of it is to introduce the reader to the who the parties are and a short summary of the dispute. Whenever I'm drafting my awards, one of the things I always think about is, could a court who is looking at the award or a third-party reader readily understand what the award is about? And that's what the purpose and part of the introduction is, to frame the award so that when you're reading through it, you know immediately who are the parties, what is the issue or the in dispute in this particular case. And if one thinks about it, that's not too dissimilar to what you would find in many court judgments. So that would always be my starting point, to briefly set out what the introduction is. Not to set out what the conclusions, of course, of the award are, because that comes much later. The second key component is setting out the procedural history of the arbitration. Now, there is, I think, different styles in terms of what goes into the procedural history. What I've just said very briefly is it's got to be the key procedural information. I think there's an element of judgment here as to what goes in, and certain institutions who be reviewing the award might want to see more rather than less. So, for example, if you're drafting an ICC award, it's frequently the case that the ICC Secretariat will review all of the correspondence between the parties and the arbitrator, and will want to see quite a lot of that in there. But if you step back from it, there will only be a few things which are really critically important to setting out the procedural history. That will be what submissions have been filed, so a court or a third-party reader can understand what opportunity the parties have had to put their case. Equally, alongside that, what evidence has been filed, if there have been any procedural orders made by the tribunal throughout, if there's been any procedural hearings. Sometimes there can be an early determination in relation to jurisdiction, so you may want to set out what, if that's been dealt with by way of an order, what order was made. But really, what as an award writer you're seeking to do here is, if to think about is, if after production of the award, that award was to be challenged before the courts on the grounds of some due process concerns, would the court be able to see from the award exactly what steps were taken by the tribunal in order to reach its decision? And that's important because arbitration proceedings are, of course, not like court proceedings. So it's a lot harder. Court judgments typically don't really set out in a lot of detail what the procedure was. But that's because in court proceedings, quite typically, you have a very sort of set procedure set down in the procedural rules, whereas arbitration is a lot more flexible than that. And also one of the key grounds of challenge is the procedure which is adopted. So it's always important when you're dealing with this section to think about it from the prism of potentially an eventual challenge to the award. Second, the third element of recommended content is jurisdiction. Obviously, the jurisdiction of the tribunal is critical because jurisdiction is an issue which can be challenged subsequently by an application, normally to the seat of the arbitration, but sometimes on enforcement. And the question of jurisdiction can be looked at by the courts on a de novo basis. So it's really important that the tribunal sets out the basis of its jurisdiction. This will typically involve setting out what the arbitration agreement is. If there have been any points of contention, or then you will want to set that out. What are the parties' submissions in relation to jurisdiction? How has the tribunal resolved that? What is the set out the basis of that decision? frequently it often happens that the arbitration agreement might be ambiguous on a particular point, or it may be silent on a particular issue relating to jurisdiction. For example, maybe the arbitration agreement doesn't set out what the seat is, and the seat has been determined by the arbitral tribunal applying the procedural rules, or the parties have subsequently agreed it. It's really important that any concessions which are made by the parties in relation to the jurisdiction are recorded in the arbitral agreement. I've set out here on the bullet points, there's a question of whether or not you incorporate an early procedural order. If there is a challenge to jurisdiction, then a tribunal usually has an option whether to deal with that challenge by way of a partial award, or to deal with it by way of a procedural order. And quite often the difference between the two will depend on whether or not a party wants to challenge that decision before the merits of the dispute are resolved. If they do want to challenge it, it's likely to be dealt with by way of an award. But if not, the tribunal may determine it by way of a procedural order. But given that it is a ground of potential challenge, then my recommendation is always to incorporate any procedural order if that's the route's been taken in full in the arbitral award. The fourth thing which needs to be set out is the applicable law and the procedural rules. Procedural rules, I think that's fairly straightforward. It's going to be institutional rules or any other rules which have been agreed by the parties. Applicable law could be, will certainly be at least the law which governs the substantive dispute. There has been quite a lot of jurisprudence recently about the applicable law of the arbitration agreement and whether or not that's separate to the governing law. So also consider whether or not it's appropriate to confirm what the applicable law in relation to the arbitration agreement is as well. Other sections of the award which should go on the checklist are the parties' requests for relief and also potential identification of issues. Now, all parties will have been asked to identify their request for relief. Typically, it's done the notice or the request for arbitration and the response. Frequently these days, there's a reservation of rights by the parties when they submit those documents, and they're more fully stated in the statement of claim or statement of defence. It's really critical, I think, for any award writer to set out in detail what relief both parties have claimed, because it essentially forms a checklist for determining whether or not the arbitrator has dealt with all of the requests for relief which have been made by the parties. And if the arbitrator hasn't, then again, that's a ground for revision of the award. And so that's a sort of key critical element to make sure that your award is safe. I've also set out identification of issues. If we've got time later on the seminar, this is something which I think is worthwhile exploring in more detail, the extent to which the tribunal requires party to identify what the issues are in dispute. What I would say for now is that there are certain rules, I mean the ICC rules in particular, which require in the terms of reference the tribunal to identify, insofar as possible, all of the issues for resolution. And of course the issues could be very different to the requests for relief, and typically are, because they will be the key issues which on which certain claims, the outcome of which certain claims will be determined. So if the parties have agreed a list of issues, or the tribunal has identified them, then it's also, I think, important to set them out in your award, because again, it will form an important checklist. Have the tribunal resolved all of the issues which have been identified? So then we come to number 7 on my checklist, which is the factual summary. The factual summary will be the background to the dispute as opposed to the procedural background to the dispute. So broadly setting out who the parties were, what is the relevant contractual nexus, setting out some of the key documents perhaps or correspondence dealing with the resolution of the dispute, or summaries from witness evidence. If during the hearing there's the witness evidence has been contested, then this might be also the section in which you set out extracts from the transcript. The idea, I think, is normally to make the factual summary as uncontroversial as possible. So you'll typically find that there's quite a lot of material where the parties do not really dispute it on either side, and that will form the framework of your factual summary. There are some disputes, as I said a moment earlier, which revolve around key legal issues, and there are other disputes which revolve around key factual matters, disputed meetings, whether or not an agreement was concluded orally or not, that sort of thing. To my mind, where you put the factual summary really it depends on whether or not you are having to make heavy findings of fact. It may well be that if you have to make heavy findings of fact, what you do is you do a very short factual summary, which is very uncontroversial or as uncontroversial as possible. And then you keep a lot of the findings of fact out to when you're setting out your reasons for your findings. Whereas if the issues in dispute are predominantly legal, then what you might do is just keep this very, keep it uncontroversial, but you might make it in the factual summary some key or short findings of fact, recognizing that you're not likely to come back to them when you're setting out your main reasons. So then we get into the meat of the award drafting. So I've set out here summary of claims and submissions. It's really important, I think, to give a high-level summary of what are each of the parties' respective positions. Typically by reference to their submissions. Some arbitrators will be very detailed and they will cross-refer to the exact paragraph numbering of the pleadings. Myself personally, I quite like to do that cross-referencing because I know that I've then done a cross-check on exactly what the parties have said and I've referenced it. I think there's a key question here in terms of organisation. If the dispute is fairly simple, then you might want to set out the summary of the claims and submissions for each party respectively. So all of the claimants' positions, all of the respondents' permissions separately, and then go into the actual award writing, setting out the reasons why you've decided what you have in relation to each of the claims or submissions. But quite often it's the case that actually what you want to do is set out in your award the summary of the parties' positions by reference to either a particular claim or a particular issue. So let's say that you have a claim for a breach of contract. Let's say it's a breach of warranty. Then you may want to say, well, the claimant says that there's been a breach of warranty and summarise what the claimant's position is in relation to that. The defendant's counter position is X. And then you have sitting alongside each other the two respective positions, and that's often a lot easier to digest for the reader than it is to see the claimant's full position in relation to all of its claims and then turning to the respondent's position in relation to all of its defences. Equally, if you're dealing with issues by relation to issue, then again, you might want to set out the positions in relation to each particular issue rather than set out the position by relation to each claim, if that makes sense. Tribunal's reasonings and findings, obviously this is the really important part of any award because, as I said at the outset, the mandatory requirement is that the tribunal sets out its reasons and findings. I think that one of the most difficult things to think about is the structure of this particular section. There are, it seems to me, two options. You having summarised the parties' respective positions, you can then go on to separately state all of your reasons. An alternative way of doing it is after you summarise parties' respective positions in relation to each claim, you then set out the tribunal's reasons in relation to that claim, or if you've done it by issue, in relation to that issue. and the extent to which you split it up in that way, I think really depends on the complexity of the dispute. Where a dispute is particularly complex, then I would tend to do it by relation to issue. So summarising both parties' respective positions, then going immediately into why you have come to your determination. And the reason for that is otherwise your award tends to get incredibly repetitive. So that's why I tend to do it in that way in particular. It's really important, I think, when you've drafted your award to go back and try to ensure that you've avoided any ambiguity in relation to your reasons and the determination that you've made, because obviously that's something that the parties really pick over and look at when it comes to a potential challenge. And they really want to understand the reasons that the tribunal has come to the decision that it has. Equally, I think tribunals should try to avoid getting too stuck on the detail. Sometimes the problem with an incredibly detailed award is that it can sort of open up the scope for challenge and misunderstanding. So I think that there is a fine balance between avoiding ambiguity and something which is far too detailed that it risks tying the tribunal in knots. Finally, the operative part, the dispositif. This essentially lists the tribunal's decisions on each of the requests. I've set out what the usual dispositif provisions normally are. I think when you're drafting this section, this is where you go back to the section which deals with the parties' relief, because you're often required, and institutions will often ask you to check whether or not you have dealt with everything which the tribunals are the parties have asked for. And if you already set out in one section of your award what the relief is, you can then go back and just cross-check that you've dealt with everything which has been asked for. Usually it's also very typical these days to include some sort of general super provision at the end, which says that all other claims are dismissed. If this is not the final award, you also may want to say that the tribunal reserves its position in relation to all of the claims or something along those lines. But that's fairly typical these days. So finally, dissenting opinion. It's not very often that you come across a dissenting opinion, particularly in commercial arbitration, but there is the ability in most jurisdictions to have a majority-only signature for an arbitral award. So the fact that one arbitral tribunal member disagrees with the other arbitrators is not necessarily an issue which will prevent the arbitral award from being issued. The question really is, how do you record that dissent? The first, this is obviously a question which needs to be checked against the original sources of law which identified, so the lex arbitri, the procedural rules, and unlikely but possible the parties' agreement. Quite often a separate opinion will be given by the dissenting arbitrator, and that's perfectly permissible. If the dissenting arbitrator does not want to write such an opinion, then the other tribunal members can simply record that they disagreed, the dissenting arbitrator disagreed with their analysis. So finally, I just thought I would give you some helpful checklists, because there is quite a lot of useful information out there if you're drafting an award and you, after drafting it, you want to go back and check that you've included all of the key components. The first is that there is a very helpful IBA ARB 40 award writing toolkit, which was produced in 2016. I was co-chair of the IBA ARB 40 at that time, and so had some role in supervising the rollout of that toolkit. And it is, I think, and still remains a very helpful document. Some of the institutional rules it refers to have been revised since then. So I would look at it, but just to always be a bit cautious to check the up-to-date institutional rules. The other document which is really useful is the ICC award checklist. So if you were to Google, you'll see that the ICC has an award checklist, which it typically sends to its arbitrators, and it will expect arbitrators to comply with that checklist when they are drafting their award. So while if you are drafting an award which is governed by other institutional rules, obviously you don't need to comply with this checklist, I still think it's quite a useful tool if you want to make sure that you've covered everything off. So I'm going to stop there, and having set out the ingredients, I'm going to hand over to my fellow panelists to give you a bit more meat on the bones in terms of the nuances of award drafting.
Thank you very much, Angie. We will now listen to Njeri. Njeri will lead us to discuss the distinction between awards and procedural orders. Njeri?
Thank you, Collins, and thank you very much, Angeline. That was very clear. I hope our participants are happy with all the information you provided to them. I noted that one person has asked that your PowerPoint be made available to them, but I think that I'll leave between you and the NCIA.
Yes, I'm very happy to share it after the event, so you can have it.
Yeah. All right. On my part, mine is a very short paper, very short presentation that I have on the distinction between procedural orders and an award. In a world where instant gratification has become the norm, it must be accepted that it will take more than a little time for a student of arbitration to grasp the distinctive difference between procedural orders, or orders for directions, as we refer to them here, and awards. Hence why it is important that the practical aspects of arbitration be taught alongside the theory. Let's start with the purpose of both. 1. An award, whether interim or final, conclusively determines an issue or the issues in dispute between the parties. A tribunal may make multiple awards on different aspects of the case at various stages of a reference. Whether a tribunal will make more than one award will be determined during the course of the reference. It can actually be said that an award is the very reason for an arbitration being set up. Procedural orders, on the other hand, are one of the tools that assist tribunals in managing a reference, and that give guidance and direction in accordance with stipulated timelines to the parties during the conduct of a reference, with lack of adherence thereto possibly resulting in costs. Procedural orders address issues such as the timetable for pleadings, types of documents to be tendered, and the schedule of hearings, and may be issued right from the date of the preliminary meeting, and sometimes even prior. So clearly, an award has to be regarded, as I've already mentioned, as the very reason behind the setup of an arbitral reference, as it will finally and conclusively dispose of the issues in dispute between the parties, while the procedural order or order for directions forms a requisite part of the arbitrator's procedural toolkit that assists in managing the conduct of an arbitration. Indeed, one may go further to say that orders for directions allow for disposal of certain matters that do not merit determination through an award. If I may here make reference to the IBA's commentary on the point by reading the following from the very book that Angeline has just made reference to, which is the IBA Arbitrator 40 Toolkit for Arbitrators. Just read this, sorry. Eyes are not very clear today. It is important to bear in mind that even where procedural orders deal with clearly procedural issues, such as setting dates for submission of statements, dates for hearings, and containing decisions on whether certain witnesses should testify at the hearing, or decisions on requests for the production of documents, they are likely to have a significant impact on the conduct of arbitration proceedings and therefore potentially on their outcome. Another point that's important, procedural orders, unlike arbitral awards, are not subject to annulment or recognition and enforcement. Further, the formal and procedural requirements for issuing procedural orders are less strict than awards. So that's just to give you, falling back on what best practice is and just giving you a brief overview of the purpose of procedural orders or orders for direction and what exactly the areas in which over which they can have some impact. Let me go further and note that the Chartered Institute has also issued guidelines on managing arbitrations and procedural orders, which reflect best practice. And at page 13, have this to say. During the proceedings, arbitrators will usually make various decisions relating to the management of the arbitration. Procedural decisions should be recorded in writing, usually in the form of procedural orders, to avoid any doubt and to emphasize the importance of compliance with these orders and to distinguish them from awards. Procedural orders do not require reasons. However, where the parties are unable to agree on a specific procedural matter and the arbitrators are called upon to decide between competing arguments, the arbitrators or arbitrator may consider it appropriate to include succinct reasons in the procedural order to demonstrate that they have given full consideration to the parties' respective submissions. On the form, procedural orders should be written in clear and unambiguous language. And I here present to you a sample of a procedural order taken from Mark Cato's The Sanctuary House Case, an arbitration workbook. Just give me a minute, please, as I try to set this up. There it is. There it is. As you can see, this one is quite detailed. And just go on to the second page. This relates to taxation of costs within that particular arbitration. And as you can see, it clearly says at the top, order for directions number 21 in respect of forms of bills of costs. If you can see, go further, it notes order for directions number 21 is by consent. It has a preamble, in fact, it has two, and the directions come lower down in the page. Let me just see if I can And the directions come from point 3 onwards, go on to 4, 5, 6, and over the page. And finally, it's dated, and the arbitrator signs his or her name. You'll see at 15, costs in the cost reference. And I will give directions as to, number 14 is I will give directions as to the procedure for dealing with costs of settlement in my ward. So it settles everything that may have come out of a particular meeting, all right? Or what we refer to also as mentions. You must always have this issued after you complete a meeting or a hearing or a portion of a hearing, so on and so forth. So in closing, I wish to note that a hard and fast template or design that does not exist on the drafting, on the manner in which procedural orders must be drafted. One ends up evolving one's own style. So please do not get fixated on what one or the other arbitrator has prepared. Best practice will be your ultimate guide. Thank you.
All right, thank you, Jerry. Thank you very much for a brief, precise presentation. Taking us on the last bit is Professor Ike, looking at the tips and techniques of award writing. Professor?
Thank you very much. And first, let me thank the Nairobi Center for International Arbitration for the invitation to speak on this very topical issue, and also to thank you, Collins, for the wonderful introduction. And I also thank my other colleagues for more or less saying all that has to be said on the topic, and being so succinct and concise about it. What I propose to do in the time left is to perhaps emphasize certain aspects that have been mentioned, and to deepen the appreciation of the importance for the purposes of our attendees. Well, let me start by making the comments which should situate the importance of this topic. I marveled at the bravery of the center to choose this topic for discussion within 2 hours. Usually, the training modules devotes about 2 or 3 days for award writing. So kudos to you at the center to try to pack all of this in less than 3 hours, into 2.5 hour discussion. But we'll try and make some progress on how to ensure that the attendees appreciate the importance of this topic. Now, let me start by making the point that the most important function and responsibility of the arbitrator is to draft a valid and enforceable award. Your award is no good if it cannot be enforced or is invalid. And it's for that reason that the Chartered Institute of Arbitrators places a very high premium on the module devoted to award writing. I'm quite happy to share this information without breaking confidentiality. If candidates do not score 70% in the award writing module, they don't get accredited. I'm not trying to scare anyone, but I'm only trying to make the point to appreciate how important it is that candidates aspiring to be arbitrators appreciate the point of being able to draft an enforceable award. It's for the same reason also that other institutions led by the ICC and other ICC-influenced institutions ensure that once an arbitral tribunal has rendered its award, the court of the ICC reviews that award to ensure that there's nothing that would prevent enforcement at the time of enforcement. So I'll leave that as that. Now, for me, most institutions have rules that govern the drafting of the award. But let's drill down to that point when an arbitrator has to start the award writing process. What is the frame of mind in which the arbitrator has to place himself or herself at the point of drafting? It's for that reason that I need us to appreciate that both the arbitrator must learn how to listen, learn how to read, learn how to write. We might take all of this for granted. We might think I'm trivializing these issues. No, I'm not. There is an art of listening, or there is an art to listening, or there is a science to listening. And those of us who are trained as mediators would appreciate what it is to listen to what is being said by the witnesses. What is it that is being said? What is it that is not being said? Why is it being said in the manner it has been said? Blink, you miss it. And that's why there's a premium on person-to-person hearings where that is available. The same attention needs to be paid to writing in a simple manner. Years ago, the same institute made it compulsory for chartered arbitrators or those who aspire to be arbitrators to come on a full-day course to learn how to write in simple English language, devoid of verbiage, devoid of any kind of language that will prevent enforcement. Simple, clear, concise language. It got so bad that most arbitrators who didn't go that course did not get any further appointments. I'm only sharing this information to show how important these institutions hold the enforceability of an award. And you want to ask yourself the question, why is it so important? Now, that is because there's a great distinction, believe it or not, between the judge who's appointed by the state and the arbitrator who's acting on for the parties. The judge is paid by the state. The arbitrator is paid by the parties to render an enforceable award. So it is a contractual obligation. Now, if the state judge makes a mistake, there's an appellate mechanism to rectify it. Most arbitration rules do not permit an appeal. The whole purpose of arbitration is to go into arbitration and obtain a swift, cost-effective decision, time and cost-effective. So there's no room for ambiguity. There's no room for lack of detail. It will have to be concise and be able to be understood by the parties. Hence the premium, hence the emphasis on simplicity. Now, apart from writing, listening, and reading and paying attention as to how we do that, whenever the arbitrator, the aspiring arbitrator, is evaluating the evidence, the submissions of the parties, the arbitrator must ensure one or two things: that he or she has given adequate attention to the submissions of the parties. There's no point cherry-picking the evidence to arrive at a preconceived conclusion. You must, no matter how persuaded you are or not persuaded you are by the parties, you must give equal attention to recount what the submissions of the parties are on every given issue. And that is why I say, at the point of drafting the award, that arbitrator must have right in front of him Article 5 of the New York Convention, which provides grounds upon which an award may be set aside or not enforced. So if at the point of writing the award, the arbitrator is constantly reminding himself or herself that I have to give equal attention to the submissions of the parties, then the requirements of natural justice will be met, and that will ensure that the award is challenge-proof at the point of enforcement. So one has to find himself or herself in a sober state of mind, weighing and evaluating the evidence, most times conflicting, most times contradictory. But there has to be an imaginary scale in the mind of the arbitrator, weighing and coming to the conclusion as to what is accepted and why it is accepted. Now, for those who want a complete, statement of the law, you will be told two things. One, there is no definition of an award. The only working at the definition of an award is that found in the ancestral rules, I think, in 1984. And that was just an attempt to propose a definition. According to Redfern and Hunter, there is no internationally accepted definition of an award. But what it is what both Angeline and Njeri have described as giving a document which disposes of all issues submitted to the arbitral tribunal and which finally determines the substance of the question or competence or procedure of the tribunal. That's what it is the final decision of all that's been submitted to the tribunal. And there's no standard way of doing it. But what must happen, though, is that award must reflect an equal attention to the submissions of the parties before the arbitrator drills down to the reasons for his or her findings. So it is Professor Ray Turner in his book, How to Draft an Award, who describes an award as a well-prepared project. It's like telling a story that everyone will follow, not a story that will confuse, not a story that will impress, but a story that covers everything that has occurred between the parties up to the dispositive part of the award. So just to put some structure, well, the award should be able to describe the parties properly, have recitals, deal with the arbitration agreement between the parties, the applicable law and the applicable rules, and of course, mention the seat of the arbitration and then the procedure that has been undertaken by the tribunal before dealing with the hearing. Now, remember, in all of this, I like to emphasize the point that the arbitrator, unlike the judge, is a fact finder, a judge of the facts. And just in case you doubt that expression, to support that expression is a statement credited to Justice Benjamin Cardoso as far back as 1921, who observed that most disputes, in actual fact, often turn on the facts. That quotation from Benjamin Cardoso, as far back as 1921 in the Yale Law Journal, is also referred to by Justice Tom Bingham in his Business of Judging book, where he quoted an article called Judicial Determination of Factual Issues. So the arbitrator's function, really and truly, is to determine the facts, drill down on the facts, which would eventually get you down to the conclusions which the arbitrator needs to make findings on eventually in the dispositive part of the award. And wearing that hat of a judge of the facts, arbitrators just need to remember the simple rules of evidence, especially in civil and commercial disputes. Because what will confront the arbitrator is very similar facts, but contradictory and conflicting. But remember, there are rules of evidence to enable the arbitrator to decipher and work out that which should be accepted, that which should be rejected. For instance, the fact that in civil and commercial disputes, he who asserts must prove. So the burden of the proving is on the person asserting. So once that burden is not discharged, then of course, whatever it is being claimed has not been made out. And I agree with my colleagues who have, I think it's Angeline, who has mentioned a checklist. There's a checklist out there which will enable the arbitrator. In fact, it concentrates the mind of the arbitrator when writing an award, is the ICC checklist. I find the ICC checklist shorter because it has bullet points which that will quickly remind the arbitrator what to look out for in drafting the awards, how to ensure that most aspects of the award have been covered. And that is why it's important, I say, that those who are trying to write awards start off by having a content and index page. That index and content page should be at least guided by what you find in the checklists, either the ICC checklist, or indeed, for ICC-related cases, in terms of reference. Because the terms of reference will include what is in the request for arbitration and the answer, and will be very clear as to what the claims of the parties are, or counterclaims, as the case may be. So the arbitrator should ensure that from time to time, he or she is cross-checking what is done against an ICC checklist, the New York Convention, Article 5, on how an award can be resisted, and the terms of reference. And if there are no terms of reference, the pleadings of the parties or the claims of the parties as they appear in the request for arbitration and the answer. Now, one question I get asked most of the time is, how do you determine who is right or who is wrong? Well, again, the arbitrator has to ensure that he has listened carefully to the parties. There are 2 or 3 attributes that will steer the arbitrator to the right answer. Probability, or what has been said by the witnesses, and consistency. Probability and consistency. If there is a letter of claim, there is an agreement that has been breached, there is no response from the respondent, surely you can see that there's a consistent line of action from the claimant. That is what steers the arbitrator or the tribunal towards the right answer. And I repeat, consistency, the repeated manner in which a party has dealt with that issue, for instance. And of course, that's of course a simple issue, but some other issues might be much more complex than that. But then probability is also another factor to take into account in being able to identify what the findings need to be made by the arbitrator. Which brings me to the question of expert witnesses. Well, the problem with expert witnesses is some expert witnesses don't understand that they have a duty to the tribunal to assist the tribunal to arrive at the right decision, regardless of the exigencies of litigation. And I'm more or less paraphrasing a decision by, I think it was Lord Justice Cresswell in a well-known English case called the Icarian Reefer. You see, in that case, the judge, who was then a judge of the commercial court, highlighted the attributes of an expert witness. The expert witness should not act as a hired gun of the party who has appointed him. The expert witness is to give evidence to assist the tribunal. But not every expert witness understands that role. And depending on the jurisdiction in which the arbitration is being conducted, you will find that some expert witnesses are only come to the tribunal to regurgitate what they've been told by the party appointing them. Of course, the tribunal has a duty to be wary and circumspect about such expert witnesses. And if the arbitrator or the tribunal is not sufficiently informed as to the duties expected of an expert witness, they might be misled by such an expert. And that is something to look out for especially in very complex construction and commercial cases, where the evidence turns on technical issues with experts in attendance. Now, the consistency and probability of testimonies is what the arbitrators will use to determine the issues. Of course, the issues we mentioned earlier on, identifying the issues is a very good way of outlining what the dispute is about, because it gives some structure as to how the arbitrator can arrive at the final conclusions. And I endorse the approach Angeline proposed, which is to be able to recount the submissions of a party on each issue, and then the findings of the tribunal. The tribunal has to indicate why those submissions on a particular issue have been accepted, why the other submissions have been rejected. And if you take it issue by issue, it can be quite helpful and give some structure to the award itself. Not to forget, because I don't know how much time I have, but one has to remember that the award has to be a complete resolution of all the claims that have been brought by the tribunal. A mistake a lot of arbitrators, or let me rephrase that, a mistake a lot of aspiring arbitrators make is forgetting to deal with fully with costs and interest. It's important to determine when interest applies to the dispute and how or whether interest will apply to the amounts due, and from when that interest applies, is it up to payment or to the date of the award, or from when the dispute crystallized. Those issues have to be made clear. There's no point fudging the issue. We've got to go back to the pleadings and determine when interest applies to the contract. Does the interest apply from the contract? Was it agreed? Is it statutory interest, or is it interest as a result of the dispute crystallizing? Does it apply till the end of the arbitration or till payment? All of that has to be made clear in the dispositive part of the award. So also costs. Costs should not be fudged. First is the inter-parties cost, it has to be dealt with. Then the arbitration cost, the cost of the arbitration, spelled out and dealt with. Then the cost of the appointing body, spelled out and dealt with. What tends to happen is most aspiring candidates just lump all of that together. It's important to separate all of that clearly in the dispositive part of the award. So I do not know whether I have covered everything I had said I would cover in short, but those would be my very humble contributions to this topical issue. Of course, finally, the parties must make sure that they have signed the award and state that the award has been signed at the seat or place where the award has been rendered. That is important. In this past, the signature of the award would have been witnessed, but that's a practice that has been dispensed with as things have now moved on. So again, those are my contributions. I intended to make it short, and because my colleagues have dealt with everything with greater clarity. But all I've done start to do is just emphasize what it is the award writer needs to be aware of, and for the award writer to be conscious of his or her position, that this is the most important thing the arbitrator has to deliver to those who have appointed him or her, and it is a contractual obligation to render an award that is enforceable. Thank you very much. And thank you for listening.
Thank you very much, Professor Ike, for your presentation with fervor and zeal. I can see that we have no questions from the attendees. So I would then use the remaining few minutes, assuming no one will ask anything, for one or two emerging issues that our panelists would wish to touch on. And then my conclusion will be that there are no questions, and therefore my panelists have really done. There's one that has come in, right? I was going to say my panelists have produced a fantastic cake. But the only thing that I wait for attendees to say thank you for the serving. All right. This is to Professor Ike. The question is, if an arbitrator puts together all costs, that is cost of parties, cost of institution, can someone challenge that in the High Court? That is the answer.
Well, a very good question. And that brings me to something I failed to emphasize. One of the reasons why it's important to pay great attention to the award you're writing is to minimize first the possibility of challenge. Secondly, the need to refer the award back to the arbitrator for correction. And it goes back to the constitutional model law, which enjoins arbitrators or arbitration to be resolved in a cost and time efficient manner. Now, if you draft an award such that issues such as cost are left ambiguous, then you've done the parties a disservice. Because it's either, yes, as you propose, the matter can be referred back to a disgruntled party might apply to court for clarification or for a challenge. Well, what surely the challenge will not succeed. What is likely to succeed is for the court to remit the award back to the arbitrator for clarity. Now, that in itself doesn't do justice to the arbitration process, because what you've done is you prevented the claimant who has paid for the arbitration to enjoy the fruits of the award. You've delayed it. So it's important that there is clarity in the cost issue, and thank you for raising that question, because what you don't want to happen is give litigation lawyers the opportunity to rush back to courts to delay the enforcement of the award. You've gifted the recalcitrant respondents an opportunity to delay enforcement. So a challenge will not succeed, but what will happen will be a remittance of the awards to the arbitrator to correct. That in itself is bad enough, is in my view. And I'm wearing my hat as a full-time arbitrator. I'm not a litigation lawyer. I'm no longer a litigation lawyer. So, and that's what happens to the process, where care is not taken to be clear on interest, on cost, and every other aspect of the award. Thank you for asking the question. Perhaps my distinguished colleagues will differ.
I'm happy to add something more to your comments on costs, which I think are Professor Ike's comments are very important. I think the issue of costs in arbitral award writing is actually quite an interesting point, because it's often overlooked. Parties are understandably really focused on the substance of their dispute and the outcome of that. And what has been, I think, standard practice in arbitration is slightly different to court practice. The arbitrators tend to issue one final award, which deals with both the outcome of the merits and quantum and costs, which means that parties are then putting their submissions in, seeking their costs, but without knowing what the outcome is. And I think the one difficulty with that is that it's quite hard for the parties to really argue about what outcome is on a basis other than they assume that they win. So you'll often have a lot of submissions which assume that the parties win. The cost schedules which are presented by the parties, there is, I think, increasingly a standard form way of doing this, but I've recently handled a challenge for the English courts where a party challenged the cost decision of a tribunal because the information which was provided by the other side they didn't think was sufficient in order to properly verify costs. Because in court proceedings, obviously there'll be a statement of truth which attaches to costs. In arbitration proceedings, often a schedule is just presented, but there's obviously no underlying verification because invoices are not produced. They would reveal privileged information. So taking a step back, I think there are a couple of interesting points, or perhaps we could think about practice in relation to costs. One, I think, is that if you've got a particularly complicated dispute, it may well be that there is some value in separating the cost decision in the same way as you would with court proceedings, so that the parties can see the outcome of the proceedings before they make submission on costs. That, in the appropriate case, may reduce the amount of time spent dealing with these things. If one party is completely won, then the other side may not even put the submission in for their costs. Their arguments might be in attacking the costs of the successful party, for example. So that's one point. The other point, I think, is that I have seen arbitrators become a bit confused about what their jurisdiction is to determine costs. And so they will seek to determine costs on the basis of court-based concepts. So whether or not they should award costs on an indemnity basis, whether they should award costs on a standard basis. The reality is oftentimes in arbitration, those principles are just simply not relevant. A tribunal has very broad discretion to determine what costs are reasonable, and they should determine it on that basis. They should not get, I think, involved in court-related concepts because oftentimes there are court procedures which go with whether or not there's assessment on an indemnity basis, which are not necessarily available to the tribunal. For example, a detailed assessment on costs. A tribunal is not going to do that. So I think if you're drafting an award looking at costs, then I would be very mindful of the jurisdiction which you're dealing with, and I would make an assessment on the basis of reasonableness rather than any court-related assessments.
All right, thank you very much, Professor Anjali. Jerry, anything to add?
Nothing. I think my colleagues have both been quite, they've covered all the bases and been quite comprehensive in their responses. Thank you.
All right, thank you. I realize that Angeline had mentioned costs as an emerging issue, and it has come up on its own. So it has been dealt with, actually. The other aspect, because now there's no other question I can see, the other aspect as an emerging issue was the question of issues, which I think Angeline had touched on, and which again Professor had mentioned something about. In my training, we do a bit of training in Jerry. We always find that issues are a problem almost for every participant, lawyers included, especially litigation lawyers have a problem with issues. Angeline, could you start us off just with the remaining a bit 9 minutes just to discuss a bit?
Sure. I think issues is really interesting because I know that parties often fight quite ferociously in defining the issues for an arbitration. I wanted to, make a proposal in a sense, and then obviously my fellow panelists may have different views. A couple of years ago, I was involved in my work for the IBA, putting together a table of grounds upon which arbitral awards are annulled by the English courts. And if you go to the IBA Arbitration Committee webpage, you can see that this is a report on annulment of awards, which was produced for many different countries, not just England. That was just the jurisdiction I was dealing with. But the purpose of the report was to seek to investigate whether or not some of the due process paranoia of arbitrators is really justified, because sometimes you see arbitrators taking a very cautious approach as to whether or not to let in evidence or further submissions, cross-examination and so forth. And as far as England is concerned, and many other jurisdictions, actually courts are pretty robust in terms of whether an arbitral award is set aside. But there is one area where arbitrators are particularly vulnerable. And it goes back to actually a point which Professor Eke raised earlier when he was speaking, which is the question of whether you listen to the parties. One of the sort of very limited grounds upon which awards have been set aside in England is where an arbitrator has not dealt with a key issue, or they've not allowed evidence or submissions in on a particular key issue in a case. So it seems to me, if there is one way as an arbitrator of organising your proceedings, which means that you do not fall into that trap and make your award vulnerable to challenge. So one of the things that I like to do when I'm running my arbitrations is to use an issue list and have it defined early in proceedings. So of course, if you're dealing with an ICC process, then you have to do that as part of the terms of reference. And I find if you draft it as arbitrator, actually the parties are quite willing to accept it. And it's more useful if you do it quite early in the proceedings. If you can't do it after request or response or filed, you might do it after the statement of case and statement of defence. And then quite often what I get the parties to do, either in their post-hearing submissions or in their closing submissions, is to sum up their positions and the evidence by reference to each of the individual issues. And then when you come to draft the award, you can draft it on the issue basis by summarising what the parties have said, and then giving your decision. And that way you make sure that you've given the parties an opportunity to actually state their case to their best ability by reference to the issues. And then you've actually determined it by reference to the issues. And in that way, you can then make sure that you have properly listened to the parties and given them every opportunity. And they have fair warning of what it is that you as arbitrator think are the important issues. And if they disagree with you, then they can add more to it. But that was my proposal in terms of thinking about emerging issues for the award writing process, which is also tied into the conduct of the arbitration proceedings more broadly. Now, I'll throw it open to my fellow panelists at this point, because they may have views as to whether or not they think that would be a successful way of running arbitrations in their past experience, or whether they think there's any other sort of risks associated with it.
I find myself nodding along with you, Angeline, because that's precisely the same way I do my own arbitral awards. I get the parties to respond as per issue. And it then makes a lot of sense in the end. And I mean, in making their final submissions, they respond as per the issues. However, and I do try and get the parties' feedback, even if they ask that I do prepare the issues. My preference is for them to do so, and I guide them in preparing the issues, and I tell them, please keep them brief. You know, they should run along these lines, and I leave it to them, because then they can't complain that she didn't, you know, respond to all the issues. They can't complain that I left them out of preparation thereof, you see. So they submit them to me ultimately for endorsement. If I'm still not happy with them, I return them, the issues to them, and get them to, you know, finalize with them. But then again, I just do it the same way as you do. Ike.
Thank you. I endorse all that has been said as best practice, and it's useful to have the buy-in of the parties to determine the issues. Now, that said, something else that assists in the formulation of issues is getting the agreed facts and facts in dispute also, identified. And moving forward from that, in the event that there is great difference, because sometimes it is just the parties preferring to express the issues in a different way. So what I tend to do is I'll go to the issues again and say, well, I'm able to deal with issue 1 for the claimant and issue 2 for the respondent. There seems to be some overlap on issues, so that gives me the opportunity to harness the submissions in support, those against, before making my findings. But there's a lot to be said in the suggestion that Angeline has made, and is good practice. Best international practice, I beg your pardon.
Thank you. I wonder what you'll say to this. I had one recently where the parties actually framed. Millicent, we have 3 minutes. I can see your face looking at Millicent. We have 3 minutes. I had one, the parties actually framed their issues and presented them. We do the trial, we finish. When they present their submissions, one had more or less like abandoned what they had framed and signed it to, and went off on a tangent. I suppose after realizing how the trial went, they thought what they had framed was not really that issue. So it's an interesting area.
Yeah, but sorry to interrupt, but that's, you see, if the parties own the issues, it minimizes the opportunity for challenge if they don't like the decision at the end of the day.
True, Professor. Any final comments, Angeline?
None from me. This has been extremely illuminating. Thank you to my co-panelists for their very interesting presentations, and to the NCIA for organising this.
Thank you.
Jerry?
I have nothing further, and I thank the NCIA for including me in this. It was most interesting.
Parting shot, Prof?
Well, thank you very much. As always, it's a pleasure to be with the Nairobi Center for International Arbitration. I thank you for inviting me to participate in these discussions. These are very topical issues, and I thank my colleagues for shedding light on their own practices. We are all better enriched by the exchange of information and ideas. Thank you very much.
Thank you all then. I must certify that the cake you baked is highly edible. I was one industry too. Thank you. Back to you, Millicent. Thank you.
Thank you very much, our moderator, Collins, the speakers, Angeline, Jerry, and Professor Ike, for a very informative session. We have truly gained from your wealth of knowledge, and really appreciate the fact that you can set aside time to share your knowledge and experience with us. Thank you very much. To the attendees, I also want to thank you for engaging with us, for making time to participate in this webinar. And to all of you, I look forward to working with you in the future. We are planning for more webinars, more seminars, and conferences. We look forward to your active participation and resourcefulness. Thank you very much from NCIA. Asanteni sana.
Asante sana. Asante.
So we are free to log off.
Okay. Asante.